Hello and welcome to this Constitution Unit webinar about the 1997 Labour Government's Constitutional Reform Programme. I'm Meg Russell, Director of the Constitution Unit, and I'm here to chair this evening's event. For those of us who remember it well, it seems remarkable that this month marks the 25th anniversary of the election of Tony Blair's first government. Today's weather seems somewhat reminiscent of that election day, even if today's political weather feels very different. That government entered office with an unusually ambitious set of manifesto proposals for constitutional reform, many of which went on to be implemented and some of which did not. The subsequent Labour governments of 2001 and 2005 implemented further constitutional reforms. So the purpose of today's event is to look back at that programme of reform, asking what happened, what the legacy is, what worked, and perhaps what could have been done better. We're joined by a senior panel who were very closely involved from different perspectives. So Professor Robert Hazel Cbe was the founding director of the Constitution Unit in 1995 and worked closely behind the scenes advising on some of the reform proposals, including by supporting the Cook-McLennan talks between Labour and the Liberal Democrats on the Constitution, joint chaired by Robin Cook for Labour and Bob McLennan for the Lib Dems. Robert's still very much an active member of the Constitution Unit, but stepped down as its director in 2015. Charlie Faulkner QC, Lord Faulkner of Thoroton, joined the House of Lords that same sunny month 25 years ago as a Labour peer. He was very much a part of the Blair inner circle and he has held various frontbench positions, including as Secretary of State for Constitutional Affairs and Lord Chancellor from 2003 to 2007. More recently, he's been a Shadow Lord Chancellor and Secretary of State for Justice, Shadow Attorney General and Shadow Advocate General for Scotland. And finally, Shami Chakrabarti, Baroness Chakrabarti, is also a Labour peer and former Shadow Attorney General. Prior to entering the House of Lords in 2016, she worked as a barrister and did work for the Home Office, and then served as Director of Liberty, the human rights advocacy organisation, from 2003 to 2016. So she was watching what was going on at that time largely from the outside and was a frequent media and public commentator. So our three excellent panelists are going to speak in that order for about 5 to 8 minutes each. And then after we've heard from them, we'll pass over to a discussion among the panel for maybe 15 or 20 minutes, and then open it out to audience questions. So do please be ready with your questions. You can submit them anytime. And we ask you to do so through the Q&A function of Zoom rather than through the chat. Lisa James, who you can see on screen, is going to be our Q&A facilitator. She'll select from among the questions that you've submitted. And as standard, we'll ask each questioner to unmute and ask their own question themselves. If you prefer Lisa to ask your question for you, that's absolutely fine. Just indicate when you submit it, and you can submit questions anonymously. This whole event, including the Q&A, is being recorded and we'll post it online afterwards on our website and YouTube channel, and it will become a Constitution Unit podcast. So you may want to bear that in mind when deciding whether to ask your own question. So that's enough from me. We're going to pass over to our panel now, starting with Robert, who has some slides to share. Robert.
Thank you, Meg. Let me say a few brief words of introduction before my first slide. To my mind, New Labour's constitutional reform programme was much the biggest programme of constitutional reforms in the whole of the 20th century. We forget just how big and wide-ranging it was. So my task is to remind you of its full extent by listing all its main elements. It's a long list, so that's why I'm going to do so using a slideshow. Before I do that, let me offer some brief thoughts on the origins of the programme. Mrs. Thatcher and the 18 long years in opposition opened Labour's eyes to the winner-takes-all nature of the British political system, and Charter 88 persuaded them of the need for stronger checks and balances. There was also unfinished business from previous Labour governments, the failed attempt to introduce devolution in the 1970s, and the failed attempt to reform the House of Lords in the 1960s. It was John Smith who first packaged Labour's piecemeal reforms as a constitutional reform programme, but it fell to Tony Blair to deliver them, even though he showed far less interest or enthusiasm. Indeed, the constitutional reform proposals were tucked away right at the end of Labour's 1997 manifesto under the heading, "We will clean up politics." And now let me try and bring up my first slide to show those 97 manifesto commitments. So here, I hope, is my first slide. And let me move straight on to the key manifesto commitments. It's a long list. Devolution to Scotland and Wales, removal of the hereditary peers from the Lords, incorporating the European Convention on Human Rights into UK law, an FOI Act, to hold a referendum on the voting system for the House of Commons, as well as a referendum on the euro, to reform party funding, introduce elected mayors for London and the other cities, and to introduce regional government in England, but only on demand. That's a very big agenda. And the new Labour government moved with extraordinary speed to implement it. They were able to do so thanks to very detailed planning before they came into government, in which the Constitution Unit was quite closely involved, and also thanks to their huge majority in that 97 election. Let's not forget a majority of 179 seats in the House of Commons. And so in their first term, they introduced the devolution legislation in the Scotland Act, Government of Wales Act in their first year. Likewise, the Northern Ireland Act, following conclusion of the Belfast Good Friday Agreement. And in the same year, the Human Rights Act to incorporate the ECHR. The following year, they introduced the House of Lords Act to remove the hereditary peers from the Lords, and also an act to introduce PR for the European parliamentary elections. But that's not all. In addition, still in their first term, they passed the Greater London Authority Act to introduce the directly elected mayor and new Greater London Authority. Likewise, legislation for elected mayors in other major cities. They introduced the RDA's Act as the first step towards regional government in England, the Freedom of Information Act, and the Political Parties, Elections and Referendums Act, PEPERA, which established the Electoral Commission and controls on party funding. So that was a huge amount just in their first term, but it left some unfinished business, in particular, Lords Reform Stage 2. There had been a Royal Commission under Lord Wakeham, which reported in 2000. They still hadn't moved to introduce elected regional assemblies in England. They hadn't held a referendum on the voting system, and in the 2001 election, that commitment was modulated so that in future it became, we first need to hold a review of all the new voting systems that have been introduced before it would be right to hold a referendum on the voting system for the House of Commons. And the referendum on the euro, everyone will remember, in effect, was kicked into the long grass because of Gordon Brown's demanding 5 tests. So in their second and third terms, there were still some very major constitutional developments, beginning with a setback. The first and only referendum held on regional government in England ended in a very decisive defeat in 2004 by 80% to 20%. But the Constitutional Reform Act, the following year, introduced a whole new swathe of reforms of the judicial system, the new Supreme Court, and a very independent Judicial Appointments Commission. The following year, the Government of Wales Act introduced for the first time primary legislation for the Welsh Assembly in a process that has continued ever since, with more powers being given to the Senedd in Cardiff. Lords Reform, there was a whole series throughout the 2000s of green papers, white papers, cross-party talks, parliamentary votes. Lords Reform Stage 2 did not happen for lack of trying. Meg's the great expert on that, and we may come into that in discussion. Quite the opposite with the commitment to hold a referendum on the voting system for the House of Commons. There was an almost complete lack of political will, because in Blair's cabinet, it had, I think, probably at most only 3 tops 4 supporters. And so it was kicked seriously into the long grass. And eventually the review of new voting systems was published very quietly in 2008. That one was buried. And as a last gasp of the Brown government, which came in with very ambitious plans to reform the prerogative powers and to codify most of them. In the dying days of that government, they managed to codify just 2 and put the Civil Service Commission on a statutory basis, as well as the conventions about ratification of treaties. And finally, I'm sure we'll come on to talk about what the legacy is of this very big program. And there are obvious things like Devolution, the Human Rights Act, FOI, a more assertive House of Lords, etc. I wanted to just dwell on something which I think is little noticed, which is the very large number of constitutional watchdogs created either as a direct effect or side effect of the constitutional reform program. So many that I can't list them all on one slide. So there are 2 slides to close, beginning with this list: the Electoral Commission, set up by Pepera, the House of Lords Appointments Commission, set up now just over 20 years ago, the House of Lords Constitution Committee, which had been a recommendation of the Wakeham Royal Commission, now 20 years old, ditto the Joint Committee on Human Rights, and the Information Commissioner, who's the independent watchdog for the FOI Act. And final slide, the Judicial Appointments Commission, which now appoints all the judges in a very independent way. The independent advisor on ministers' interests, little noticed at the time, but who's been very prominent in the last year or so. The EHRC, set up as a new independent watchdog. IPSA, which was set up following the MP's expenses scandal. And I've already mentioned the Civil Service Commission, which was given a statutory basis in 2010. So that ends my presentation. Very briefly, forgive me for such a rushed presentation, but there was a lot I wanted to get through. I'm sure there's lots more we could discuss, including perhaps the unfinished business. So items like Lords Reform Stage 2 that I've mentioned, a British Bill of Rights, which is now again very current, difficulties over the government of England, etc. But let's leave all that for discussion later. And let me hand back to you, Meg. Thank you very much.
Thank you very much, Robert. You've done us a great service, I think, by presenting all of that stuff very succinctly so that others don't have to remember all the names and dates and list it all. And I hope that the audience will be sympathetic when they discover that we cannot possibly do justice to talking about it all. But let me pass to Charlie to pick out the bits that he would most like to highlight, looking back 25 years on, for their importance, their successes, their frustrations, their overall purpose and achievements. Charlie.
Thank you very much indeed, Megan. Thank you, Robert, for such a comprehensive summary of the things that we did during that period. I remember on the Friday, we got elected over Thursday night on the 1st of May. And then on the Friday, there was huge, real huge interest in the result of the election. Obviously, there always is, but on this occasion, more than ever. And I remember I had a helicopter that was filming Mr. Blair's car driving to the palace in order to become the Prime Minister. And the streets were, insofar as they were empty, there were people who were sort of there cheering Tony on. And then there was some lights that went red and his car stopped at the red lights. And I thought, a government that certainly complies with the rule of law, I thought to myself, a thought at the time that has particular piquancy, I think. Can I make essentially 3 points? First of all, the mood in 1997. The mood in 1997, and Robert has touched on this, is of a constitution that had been allowed to stagnate over an 18-year period with a government that seemed uninterested in the constitution of the country, and as a result had allowed the non-English parts of the country to be mistreated, and had allowed the rights of individuals to wither, and had allowed our constitution to become incredibly old-fashioned and unresponsive to the public. The sense of opportunity that existed in 1997 for the Labour government was huge, and we took that opportunity in the ways that Robert has said. But in 1997, with the possible exception of Northern Ireland, the constitution was not in crisis. And the pressure in relation to the changes in the constitution were not as a result of mass constitutional failures, which left large chunks of the population feeling that they were disempowered by the constitution. Two particular areas I would like to focus on the things that we did. First of all, in relation to the Human Rights Act, in relation to the Freedom of Information Act, in relation to data protection, and in relation to judicial reform, we completely created a much more driven rights culture. We were, in effect, genuinely empowering individual citizens to protect themselves against the executive. And those changes did represent a fundamental shift of power away from the executive to the individual. And the Human Rights Act is a part of empowering people to exercise legal rights in English courts. The Freedom of Information Act is something that forces the government to be much more open in relation to what we did. Those suite of reforms, and judicial reform is in them, because the effect of the judicial reform was to absolutely free the judges. I'm not saying there wasn't an independent judiciary before, but the Judicial Appointments Commission, the removal of the head of the judiciary from the executive, the creation of the Supreme Court absolutely battened down the sense of a court that was not part of, inverted commas, the government. That range of individual empowerment changes, in my view, have been a total success. The other area where there was a really big success is in relation to devolution and the Good Friday Agreement being implemented. It's not an underestimate to say that the effect of the Good Friday Agreement was to completely transform the governance of Northern Ireland in a way at that stage which was completely satisfactory to the two communities in Northern Ireland. As far as the nationalist community is concerned, the border was dismantled, and although Northern Ireland is constitutionally unquestionably a part of the United Kingdom, lives could be led in a way that gave effect to the aspiration of the island of Ireland without a border. And as far as the unionist community is concerned, they felt that we had absolutely gold-plated in the sense that Northern Ireland would always remain a part of the United Kingdom as long as the majority of the United Kingdom wanted it. And although there have been bad things happen from time to time, in particular the suspension of the Assembly, but also terrorist activity since 1998, nevertheless, has been a very fundamental shift in relation to Northern Ireland. And I'm conscious of the fact that I'm speaking at a point when the Good Friday Agreement is to some extent under threat. But those 25 years have been 25 years of peace. I pay tribute to the Conservative government for starting that process, but the bold constitutional moves made in the Good Friday Agreement cemented that in. In relation to devolution, particularly in Scotland, but also in Wales, it would have been unthinkable for there not to have been devolution to Scotland and Northern Ireland without there being a devolved parliament in Scotland and a devolved assembly in Wales. Then the pressure for a fracture of that part of the union, or those parts of the union, would have been much greater. I completely appreciate that the demand for separation is much, much louder now in 2022 than it was in 1998, but that I don't think is because of devolution. I think that is because of other factors that have led the government of the United Kingdom, and this is not necessarily an anti-Tory attack. The government of the United Kingdom based in Westminster looks to a lot of people, particularly outside London, as a government that fails. So I say individual rights and devolution and the Northern Irish settlement are things that we should feel really proud of. I don't say that's the only things we should feel proud of, but those are the two things I'd like to highlight. There are three things we didn't deal with. First of all, parliamentary sovereignty. Everything we did in the context of the conventional view of parliamentary sovereignty. Query whether that was right in the light of what is now happening in relation to an executive which controls Parliament and therefore does not see itself as bound by the usual checks and balances. And equally, it gives rise to the sense, particularly among the devolved bodies that their devolution is not appropriately grounded in constitutional safeguards that mean you can't go back on devolution. Secondly, we did not deal with the electoral system. So the electoral system remains the unfair system it's been for a very, very long time, with all of the pressures that forces onto a government, which makes a government take for granted too much of the electorate and focuses too much on small slithers of the electorate. And thirdly, we never dealt with the English problem, by which I mean England is unfairly treated by our constitution. Of course, it's fairly treated in one sense, in that it has 70 or 80% of the MPs, but the regions, despite all our efforts, the RDAs, the attempts to introduce regional assemblies, feel mistreated. Mayors and RDAs were not enough. And that part of the constitution is something we really need to address now, because, as has been proved by the Brexit process, as has been proved by the failure of Parliament effectively to deal with Brexit for 2 or 3 years, as has been demonstrated by the fact there is now no settled sense of what the checks and balances are on the government, there are a whole range of new problems not caused by the constitutional changes before, but created by the new economic history of the last 10 or 15 years, which means our constitution is now in crisis, and we need to look again as to how we reset the constitution. Thank you.
Wonderful. Thank you, Charlie. I think that was a good plug there at the end for the Brown Commission and its work.
Well, of course.
If I understand the Brown Commission correctly.
Yeah.
There's fascinating stuff in there, lots of things I'd like to ask you, but before we open it up to discussion, let's pass over to Shami. How did it look to you? You're muted.
Yeah, sorry, I'd have to get used to doing these things by Zoom again, but not necessarily in lockdown. Daunting privilege as always to follow Robert and Charlie. For the first term of the New Labour years, I was a lawyer in the Home Office, so I did have a bit of an inside track on the development of the Human Rights Bill that then became the Act. I did a little bit of advice on the Good Friday Agreement, and I was around when colleagues were working on both devolution and FOI. And my memories of that period in my late 20s and very early 30s were of considerable genuine excitement and positivity, even from officials and, to use that horrible word, stakeholders and others about that agenda. And it's a minor point perhaps about machinery of government and the culture of different departments, but it's important to say that the wicked old Home Office in those days was not the Ministry of the Interior that it is today. It was more complex. It was a combination of a Ministry of the Interior, but it also had responsibility for things like race equality, human rights, and aspects of the constitutional reform agenda. By contrast, the old Lord Chancellor's Department, now the Ministry of Justice, was really much more focused on the courts and the judiciary. Now, of course, that changed over time, and Charlie was later instrumental in that deal, which partly meant that the prisons, which were always a nightmare for any Home Secretary, got passed to the Justice Secretary and so on. But from my own experience, it was kind of nice when having to grapple with hideous work on things like counter-terror and immigration and asylum and criminal justice, to have a little bit of light, a bit of lightness in one's diet and be able to feel at least positive about things like the Human Rights Bill. I'd also want to, just pay tribute to, I was a relatively junior official, even at the end of my stay. I just made it into the senior civil service before I left, but I really had the privilege of working with fantastic lawyers. The late, great Juliet Weldon was my boss as a Home Office legal advisor, and then she was the Treasury solicitor, but also some amazing parliamentary counsel who again got quite involved in quite and inspired by the project. Edward Caldwell drafted the Human Rights Act, which I think is not just a wonderful modern Bill of Rights, and all this stuff about contrasting the Human Rights Act with bills of rights. The Human Rights Act is our modern Bill of Rights, and in contrast with what is currently being proposed, it is an actual progressive Bill of Rights, as opposed to something pretending to be a Bill of Rights that is about restricting individual rights and enhancing executive power. Edward Caldwell drafted the Human Rights Act, which I think is an exquisite piece of drafting. Ewan Sutherland, a Scot, drafted the Scotland Act, and you can just tell by the drafting, you know, how do you draft the beginning of the Scotland Act when you are a Scot, and you know there's been this, you know, this long period where people have been yearning for a Scottish Parliament. You begin with the words "there shall be a Scottish Parliament." So it was a very, very exciting time to be working on that agenda. I mean, I think Charlie is very good at doing balance. This is why he's such a dangerous advocate. You know, I was thinking I must put some balance into this panel, because yes, I was part of that that process as a civil servant, but I went on to be Director of Liberty and to be critical, and quite highly critical, particularly during the War on Terror. But what I will say, because we're talking about the constitutional issues today, and not necessarily about that broader agenda of which I was often critical, what I would say is this: the Human Rights Act probably was, in the eyes of the people of this country, snuck in like a thief in the night. And that is perhaps unfortunate, that it wasn't, that there wasn't a fanfare of trumpets, there weren't, you know, choirs of angels. It was the opening of a paper bag, really. And I felt, as a junior official, that some ministers almost had cold feet, perhaps when they had been advised by my colleagues, particularly some of my more small c conservative colleagues, about what this would mean in practice for your other policies around things like criminal justice, anti-terror and immigration. So that will give any minister in a Ministry of the Interior the slight heebie-jeebies about the Bill of Rights that they are introducing, but they did it nonetheless, and that is something to be enormously proud of. And indeed, when they set up the new various commissions that Robert talked about at the end of his presentation, they often put people in charge of them who were not sycophants and not place people, and were capable of being quite critical of government themselves. But I think the first sadness is, for me, that the Human Rights Act was not given greater fanfare, there was lots and lots of consultation, I would say, across parties and with experts in the preparation of the Human Rights Act. And I think it is an exquisite British constitutional compromise in the way that it copes with sitting there in a Bill of Rights that sits in a largely unwritten constitution, where we have parliamentary sovereignty as the overarching principle. So what do you do for enforcement? I think the Section 3 interpretative power, the Section 4 declaration with moral force but no strike down, the Section 6 duties on public authorities, including courts, is a pretty exquisite constitutional compromise and a beautiful piece of legal policy and drafting, but it wasn't sold to the public. It wasn't explained to the public. If you think about some of the great public information campaigns of my lifetime, whether it's to introduce seat belts or other aspects of public policy, that this was not done. I don't believe people got so much as a leaflet, let alone, you know, a big public information campaign. And I think that is a real shame. And of course, later, when you did have things like the War on Terror, and indeed cuts began to legal aid, to civil legal aid in particular, you have the sort of tragedy that the lack of enthusiasm and public information was compounded by a developing narrative via the news and the news media that human rights are for criminals, terrorists, foreigners, all the people who did still have a bit of legal aid and whose cases were being heard in the courts. And of course, that's all further compounded by the print, the print media who didn't want the Human Rights Act because they were terrified of Article 8 and people's privacy. And given what happened with phone hacking and Leveson and so on, you understand why they were terrified, because they were up to some pretty outrageous abuses of power themselves. So I think that is all unfortunate, and it now sort of plays into the hands of some of the people who were sent out by the Johnson government to be the slightly more respectable people with law degrees who were told to go out and trash the Human Rights Act. And there are some perfectly respectable legal academics even and practitioners who were sent out to undermine the Human Rights Act and suggest that we should have this anti Bill of Rights. And we obviously look forward to reading the actual draft bill. And one of the things that they do, and actually Dominic Raab years ago, the current Justice Secretary, had a go at this exercise himself. He wrote a book, a fairly weighty tome, where on the one hand, he talked about all the criminal offences and overbroad police powers and civil contingency powers and all these war on terror things that were done by the Labour government. And then he said, and this is why we must scrap the Human Rights Act, because the Human Rights Act didn't prevent these things happening, which of course is a ridiculous sleight of hand, because no Bill of Rights stops things being legislated for, but it will give some remedies to people after the fact. It's almost the equivalent of saying we shouldn't have a crime of murder because it doesn't actually stop murders happening. If you're lucky, there might be some redress after the fact. So to trash the Human Rights Act on the basis that it didn't prevent, the Belmarsh policy from being implemented, well, it didn't, but it did. It did allow the government to be held to account in the highest court, and that government did actually then try and respond to the judgment. But because of this draft of other legislation, not in the constitutional sphere, but that did interfere with rights and freedoms, and did actually, Charlie, give quite a lot of power to the executive, that argument has sometimes been too easily deployed by people who don't believe in rights in the way that you and I do. I have to agree with Charlie that the English problem wasn't dealt with, other things weren't dealt with. And I guess when I was that age, I sort of still believed in the unwritten constitution. I kind of thought that if it ain't broke, don't fix it. And the sort of gentleman's agreement type of approach, had rubbed along for long enough. Now I don't think there are any gentlemen left in the room. And we are I do think we're much closer to a genuine constitutional crisis now, with people who have little respect for the rule of law internationally or domestically. And it is a very, very serious, situation indeed.
Thank you so much, Shami. You've all made some fantastically important points. Let me try, and you'd probably like to respond to each other, and I'd like to encourage you a little bit to respond to each other, but let me try and get that conversation going by sort of suggesting some things that you might do so on. The point that Shami makes about the failure to sell, in particular, the Human Rights Act, I wonder whether Charlie and Robert have thoughts on that. I mean, it is often said that the programme as a whole wasn't adequately sold as a kind of coherent programme. Indeed, Robert, you might remember those words from Derry Irvine about there being no overarching theory or some such. I meant to look those up before this event, and you may hold them in your head. It may even have been at a Constitution Unit event that he said them. That kind of approach of over pragmatism was criticised, and I don't know whether this is connected in any way to Robert mentioned John Smith, and one of the criticisms that was often levelled at Tony Blair was that he wasn't really himself that passionate about this programme. He was interested in other things, and one of the reasons why so much happened so quickly was because of the restrictions on spending in the early Labour years, the commitment to not increase spending, and this was stuff that could be put through that was radical, that didn't have huge spending commitments. So Charlie, Robert, do you have yourselves any sense that maybe this all could have been sold in a more convincing way to bring the public with the government to sort of protect the gains made rather better? Charlie?
Well,
Robert's unmuted. I don't know whether Robert wants to go first.
Robert, after you.
Let me go first briefly. I know a little bit of history. There was a very strong overarching narrative in earlier Labour Party policy papers in the early 1990s, very big, weighty documents, Meet the Challenge, Make the Change, which I think was in 1991, and another policy document called A New Agenda for Democracy in 1993. So when John Smith was leader, there was a very clear, strong overarching narrative. And as I said, he first put together all the rather piecemeal constitutional reforms that Labour had gradually signed up to during their long years in opposition into a coherent programme. But as I've said, and I think Charlie also wouldn't disagree, Tony Blair was in no way so interested or committed as John Smith. And interestingly, when Blair was party leader and subsequently Prime Minister, he never gave a single speech about constitutional reform, with one exception, and that was the John Smith Memorial Lecture in 1996. And it was in homage to John Smith, in recognition that this was John Smith's, great passionate cause. But the lecture, and I think it's still available online, is a shopping list of all the reforms, the same list, that I've just read out at the beginning, without a very strong coherent theme. And Meg, you're quite right, in the early years of the new Labour government, when Derry Irvine, in effect, was constitutional supremo, we invited him to give a public lecture. And in issuing the invitation, I asked him to address precisely this criticism. And the lecture is published by the Constitution Unit. This is one of our very early reports in the unit report series. And again, I invite people to go back and read it. I remember at the time being very unconvinced. Derry, again, actually just delivered a shopping list, and there was no overarching narrative. And so I think that was, at the time, a difficulty in explaining to the wider public why these reforms were necessary and should be welcomed. They had no difficulty in Parliament, as we've discussed, because of the huge majority, and that's how they were able to pass these things so very quickly.
Two very quick interventions. First, I should have reminded people to put their questions in the Q&A. There's some coming in, but we want to gather up a few so that we can start that question session after this. And also to say, yes, Robert is quite right. Derry Irvine's speech is published as one of our reports, and all of those reports are available on our website. So if you scroll all the way down to 1998, you can read what Derry Irvine said. But Charlie, do you agree with that criticism?
To some extent, I do. I mean, there are two bits to that, I think. First of all, Tony Blair, as the Prime Minister, leading the first Labour government for 18 years, was absolutely determined to connect with the public. He, as the leader of the government, had to make decisions about what would be in the forefront of what the government was saying in order to attract political support. And it was improving the public sector, a lot more on modernizing and changing the lived experience of people. This was in the context of a government that had got to power without there being much pressure for constitutional change from the wider electorate. And so I think it's very difficult to blame Tony for focusing on the things that were electorally important. Having said that, and Robert has adverted to this, he absolutely gave Derry his head in relation to driving through this incredibly far-reaching suite of constitutional changes. Robin Butler has reminded us that a constitution unit was set up in the Cabinet Office, chaired by or headed by Kenneth Mackenzie, and Kenneth Mackenzie and Derry Irvine were an absolutely formidable force within government. Without them, there would never have been these changes. And Tony saw that and encouraged it internally to happen. He did not define himself at any stage as being the Prime Minister who made all these constitutional changes, though from time to time that played a part in his narrative. He defined himself as a progressive politician who economically revamped the country in a number of ways, and he had to make those choices. If there had been, as Shami said, more of a fanfare, as Robert says, a better narrative, that would have perhaps made for a greater acceptance of the changes. Shami said, I think just before this thing started, it never got taken into the hearts of the British people. And I strongly agree with that. But would it ever have been brought into the hearts of the British people at the time that it happened? Would it ever have been brought into the hearts of the British people with, in effect, an opposition? And this is not a criticism of the Conservatives, though it really is. But they were hammering away at, the Human Rights Act is for criminals and people who were breaking the law and bad people. Was that not always going to be a debate in people's minds? And the thing that we need to do is, as it were, remain steady in relation to our support of the Human Rights Act and the human rights principles. And I think you will find that most governments, probably including this one, will not have the nerve to make fundamental changes to it.
Something really interesting that Charlie said in his remarks, I thought, and it's interesting, we could tie this together with the question about the importance of listening to the public's priorities and public opinion, perhaps. Charlie made this point about whether it had been an error to hold on to the principle of parliamentary sovereignty with respect both to the Human Rights Act and devolution. And we can tie that to the work that we've recently been doing, which Shami kindly was on the advisory committee for and came and spoke to the Citizens' Assembly on democracy in the UK. The work that we did through our recent Citizens' Assembly and polling has suggested that actually there's quite a lot of public support out there for more power for judges, which was not really what we expected to get from the poll. So, Shami, would you go along with this suggestion that maybe the Human Rights Act should have given more power to the judges contra Parliament, which was a very controversial thing, and potentially that there should have been a different devolution settlement that also entrenched those bodies and their powers more strongly?
I don't think I can say that with hindsight. I think, firstly, I have to accept aspects of Charlie's analysis. When you are doing constitutional reform and there hasn't been a civil war in your country, and you're not rebuilding, this is not South Africa in 1994 building a new state after apartheid. This is not the US after its colonial experience and its civil war, etc., etc. It's a really tricky matter, isn't it, to be doing constitutional reform when there hasn't been that kind of crisis that gives you the year naught founding fathers kind of a moment. And I think that's, that has to be recognized. And I totally understand the realpolitik of wanting to prioritize, school education, and the health service and Sure Start and other people's needs. And I think the Good Friday Agreement was a response to a genuine crisis that had been ongoing. And again, I have to agree that was a huge success. I don't think at that moment, as a first term piece of business, you could have introduced strike down powers in the Human Rights Act. And if you had, I think we might have lost the Human Rights Act some time ago, actually. And and whilst there is a new constitutional crisis now, I think again we have to be a little bit fair to Charlie and his colleagues in the light of the fact that what Johnson's Conservatives managed to do, and if they are even Conservatives in a sense that I would have observed years ago at all, what Johnson's government and fellow travellers have managed to do is to turn a European argument that was a civil war within the Conservative movement for so many years. They've been able to turn that into almost a civil war in the British polity, and they've seized power via, you know, a type of Brexit that has excited appetites that may never be sated. And now that you've got your Brexit done, and you've got a cost of living crisis and a potential crisis in Northern Ireland, you feed the beast with the inevitable attack on the Human Rights Act and those wicked European judges and British judges, because of course in recent years we had the illegal prorogation of Parliament, which was in itself an attack on parliamentary sovereignty that was being described by Johnson and Cummings before they fell out as you know, dealing with the will of the people. The will of the people has been described in recent years as something that isn't even the will of Parliament, let alone the judges. So I don't think that the current crisis can be totally blamed on the constitutional aspect of Charlie and Co.'s package, but there's certainly more deep-seated and broader problems about alienation, about people's feeling towards elites, about quite possibly the response to the financial crisis in 2008, and whether all of those things were properly dealt with. The crisis in institutions and trust in institutions, rather than, you know, we should have given more power to these supposed elites in terms of strike down powers against Parliament.
Let me try, I'm going to pass over to the public questions in a moment, but let me try one more question, which was sparked by some of the things that you said, which is also about sort of boldness, lack of boldness, whether things should have been done more boldly. I was interested that Charlie said that it's inconceivable that we shouldn't have moved towards having a Scottish Parliament or Welsh Assembly or Welsh Parliament as it is now. But of course in Wales it was absolutely conceivable, because it was a very, very narrow referendum victory. And later on, as Robert said in his slides, in 2004, one of the things key to stopping the whole English devolution programme in its tracks was the defeat of that referendum, which Shami's been the first person to mention Dominic Cummings, but he had a significant part in that because he was very involved in the no to the North East devolution proposals. I wonder whether, was there not enough boldness perhaps on devolution to push ahead somehow on devolution in England? Was it not sold well enough? Because actually you've all, I think, mentioned devolution in England being a gap, and that was the blocking point, really. Robert, do you have reflections on that? You thought a lot about devolution.
Yes, can I just mention in connection with boldness, Gordon Brown, because we've talked a lot about Tony Blair, and it's often forgotten that Gordon Brown himself was a passionate constitutional reformer. In Blair's first government, there were only two people who were really committed to the constitutional reform programme, and they were Robin Cook and Gordon Brown. But neither of them had portfolios that enabled them to say anything about it, or at the time to do anything about it. So when Gordon became Prime Minister in 2007, he had this huge pent-up interest. And in his first week as PM, published a great big white paper called, I think, The Governance of Britain. And when speaking about it, he made no bones, and this is very unusual, I think, for a Prime Minister, in saying that he wanted to see us move towards a written constitution. Those were the words he used. And as a first step towards that, he wanted to see a British Bill of Rights, which he called a British Bill of Rights and Responsibilities. So we mustn't forget that that was always part of New Labour's programme. And there is some overlap, I think, between the Tories' recent attempts to reform the Human Rights Act. New Labour formally was never satisfied on its own, just with the Human Rights Act. That was always going to simply be stage one. So coming to Meg, your question about the governance of England, I mean, yes, it was always the difficulty of it being devolution on demand, and therefore being subject to public acceptance in a referendum. And the offer made in the Northeast referendum was a very feeble set of powers, because in truth, only John Prescott, at the time the lead minister, was the one who was willing to devolve significant powers to a new elected regional assembly, and other cabinet colleagues held back. I don't know, though, whether if there had been a wider set of powers, whether it would have made much difference, because Dominic Cummings ran a brilliant no campaign with his inflatable white elephant that appeared at all those regional events in the Northeast. So I don't think there are any easy answers on the English question. And you're right, Ray, we wrote a book about it together, you and I. Again, anyone who wants to can go back to that. I think it was published in 2005. And there weren't any easy answers then, and there aren't any easy answers now. So personally, I don't blame the Labour government for having not solved the English question. It is a really, really difficult set of questions.
Charlie, I don't know whether you've got any reflections on that. I mean, when you think about that campaign, of course, one of the opportunities for success is that it happens much later. We've talked about that sort of great sense of optimism in 1997. Now we're talking about 2004, quite late in the second term, when it's quite easy to have a referendum to kick a government and say, we don't want any more politicians. Was there a way of doing that better, Charlie, do you think?
Yes, and there were two very deep problems in relation to the Northeast referendum for regional assemblies. First, the government didn't really support it. It was very much John Prescott driving it on his own. And he was in the right place, I think, and the rest of us were in the wrong place. And secondly, the government at the time, and I think governments have continued to feel this, were informed by a sense, a wrong sense, a sense that has been fatal to constitutional development, that local government is essentially an ineffective and bad thing, and regional government would be no more than an sort of inflated local government arrangement. And if you have an attitude, which is an attitude hugely held by the current government, but it was held by the previous government as well to a certain extent, then if you yourself don't believe in the idea of proper regional government, which I don't think the government really did in 2004, then it's never going to get off the ground. I mean, Hazel refers rightly to the inflatable white elephants, but that was a campaign run against a government that wasn't really trying. Well, it wasn't. I mean, John was trying incredibly hard in relation to it, to the extent, as we were told around the cabinet table one morning, that things were not going well in the Northeast referendum, because John had recorded a large number of telephone messages that were going to be automatically sent to people's telephone numbers, and unfortunately they're all being automatically sent at 3 o'clock in the morning. So as people in the Northeast were woken up by the telephone ringing at 3 o'clock in the morning, they had John down on the phone telling them they had to vote for a regional assembly, which you could probably think would be the biggest recipe for people not voting it. But we've ended up with this incredibly centralized, and this is a cliche, but it's true, this incredibly centralized political government, and that huge political centralization is reflected in a country that is incredibly economically imbalanced, more economically imbalanced than most other European countries. How do we solve the problem? There has to be a real drive, and it's not, you can't just send Channel 4's headquarters out to Leeds and hope that equals, the end. You've got to think of ways whereby genuinely political power is devolved to regional parts of the body politic, which I think we need to do pretty urgently, because we've taken back control from the European Union, to use the language of Dominic Cummings, but we haven't taken back control and given it to the communities that most felt their positions were not understood by by Europe and now by central government.
I'm very keen to bring the audience in. Shami, do you want to say something quickly before I do?
Just briefly, I have to disagree with Robert when he said that there is some relationship between Gordon Brown's approach to a written constitution and a further Bill of Rights and what's currently being perpetrated and proposed by the government. As I understood it, by then I was Director of Liberty and no longer on the inside, but I was pretty closely engaged in these debates and conversations, including with Number 10. And the sorts of things that were being proposed for this further Bill of Rights were things like socio-economic rights and additional incorporation of additional international rights, including of the social and economic nature. What's being proposed in the current so-called Bill of Rights is a diminution, no new rights, but a diminution of the accessibility to courts and to existing rights. So getting rid of interpretation in Section 3, getting rid of declarations of incompatibility, and saying that you have to be a good person and a British person, not a human person, to be able to access these rights, and crucially breaking the link between domestic courts and the Strasbourg court. And that is when you get into violating the ECHR itself, drafted by Conservative lawyers. One final point. It's all very well to say we should have gone further, we should have had a written constitution, but whoever you are, Liberal, Labour or Tory, I mean, careful what you wish for. I think, constitutional reform should be by consensus. If it's not going to come out of a civil war, then it's got to come out of a civil conversation, and it's got to be a cross-generational from every region and nation in the kingdom, and it's got to be bipartisan. Otherwise, I think it's fraught with absolute peril.
Beautifully put. Thank you, Shami. Let's bring Lisa back onto the screen and she can pick out some questions for us. I can see there's lots of questions coming in. We must finish by about 15:15. So what do you want to throw at us, Lisa?
Yes, we've had some great questions. I hope we might get to 3 rounds, so I'm going to ask people to unmute themselves.
I would be very surprised if we got to 3 rounds.
Yes, then I'm going to ask people to unmute themselves and put their questions succinctly if possible, but we're going to start with a couple of questions about processes of constitutional reform. So in particular, we'll start with Francesca Klug and then Keith Raffan. Okay, Francesca, you can unmute.
Thank you very much, and thanks.
Welcome back.
Thank you. Thanks to all the speakers for a fantastic discussion. It's been brilliant. Shami makes a hugely important point about the failure to consult on and then promote the Human Rights Act. As Charlie says, it ushered in a massive enhancement of people's power to hold the executive to account, except the government decided not to tell anyone. As a consultant to the Home Office on human rights at the time, I recall plans for a great celebration to usher in what was then recognised as the first Bill of Rights for this country since 1689, as well as proposals for an explanatory leaflet to be sent to every home in the country. This proposal was then reversed faster than the speed of light, and few attempts were ever made to explain the huge difference the HRA has made to victims' rights, for example. Can Charlie please enlighten us as to why? Thank you.
We might have to invite you back to answer the question yourself, Francesca, if you can't. Keith. Yes. Keith, are you speaking? If you are, you're very, very quiet.
Well, I'll shout as best I can. I'm on a bad line.
Perhaps, have you written your question down? Because perhaps Lisa could read it for you. You're very quiet. Lisa, why don't you read Keith's question for us?
Yeah, so Keith asks, whilst devolution is a continuing process and not a single past event, Labour implied's proposal to expand the Senedd from 60 to 96 members is proving highly controversial. How would the panel introduce such significant reforms in order that they can win wide public acceptance and not undermine the devolution settlement?
Whoa. Well, Charlie, Francesca's question was thrown down as a challenge directly to you. Do you want to go first?
Well, I think I hinted at what the reason was in an earlier answer I gave, which is the political direction of the government was much more focused on economic and public sector reform than it was on constitutional reform, for purely political reasons, by which I mean the things that would make us attractive to the electorate were judged by the leadership of the party at the time to be much more those economic and public service issues than constitutional issues. And Tony Blair, as the leader of the government and the Prime Minister at the time, was incredibly keen to make it clear that we weren't a government of lawyers, but we were a government of people trying to connect with people in relation to the particular lived problems that they had. In the context of, using Shami's language, taking the human rights into your heart, it had a bad effect. I don't know the extent to which a much more concerted campaign, including a leaflet, including Tony himself espousing this as one of the great achievements of the government, what difference would that have made? I think it would have made some difference, but Shami's point is very important as well, that these changes were not coming out of huge popular demand, nor were they coming out of a notorious breakdown of our society, which led to the need for constitutional changes. These were changes coming from a group of a party that was committed to progressive change and took this huge opportunity that had been given in 1997 to introduce that change. And so it would have made a difference, but it wouldn't, I think, have made the country take it to our hearts in the way that Shami is referring to, because brutally, quite a lot of the electorate were not that interested in these changes.
Francesca's left the screen, but it sounds like she's got a very interesting story there about this leaflet, and maybe we need to see her write up the story of the leaflet, and maybe even write the leaflet and publish it now, because now might be the time that it's needed to convince people of the Human Rights Act arrangements as they are. I can see that Francesca put a big comment in the chat for anybody who'd like to see on this contention about the Bill of Rights proposals at the moment. Robert, do you have thoughts on Keith's question about devolution, perhaps?
Yes, quick answer on the size of the Welsh Assembly. At the start, the Welsh Assembly was deliberately kept very small with very limited powers because of the rather hesitant vote in the first referendum in 1997. Its powers since then have been significantly increased, but its size is still the same, 60. Remember, the Scottish Parliament, it's 129. The Northern Ireland Assembly at the start was 108, it's now 90. I'm in no doubt the Welsh Assembly is too small, particularly now it has significantly increased powers. How do you get public support for an increase in its size? My answer would be to hold a referendum. So there have been referendums held in Wales before it was given further primary legislative powers. That's a good precedent for holding a further referendum. And I'd link that briefly, if I might, to the discussion about people taking the Human Rights Act to their heart. And it was always from the start a rather elitist top-down project. And one way, and I remember having this argument with Jack Straw, Charlie's successor as Lord Chancellor and Justice Secretary, trying to persuade Jack, first of all, to have something like a citizens' assembly that would craft a British Bill of Rights, and then to put it to a referendum to try to get much wider public support for it. It's not the content of any human rights bill. Read the Canadian Charter, which is word for word almost the same as the Human Rights Act, and it commands huge public support in Canada. It's the way in which it is introduced, or in our case, I think it needs to be reintroduced. That was what I was trying to persuade Jack of. I failed then. I'm not convinced I'll succeed in persuading people now.
Can I just come in? What Robert said is very interesting, but the Canadian experience is of a broad political consensus behind the Charter. What you've got in the UK is the Human Rights Act being used as a political football. So an over-woke culture is attacked, and the Human Rights Act is part of it. I mean, it is extraordinary that the government, the Home Secretary and the Prime Minister feel able to attack our immigration policy is the product of, quote, liberal lawyers, which is in a sense an attack on the Human Rights Act. It is because of the failure for there to be a political consensus behind it that it remains in play. And it is very easy to attack fundamental rights given to people, when very often and quite legitimately, people on the wrong end of state activity are in some senses people over whom there is a question mark, and that is used as a wrong means of tainting the Human Rights Act. Only when the Conservative Party accept the validity of it will it be possible to say it will be taken to our hearts, I fear.
Shami, do you want to come in on this round?
All I would say, I agree with much of what Charlie said, as I often do, because he's such a seductive advocate, as much as anything else. But we're missing out the bit that is, the second Labour government, the war on terror, all of those criminal offences, all of that actually playing into the anti-immigration, anti-refugee agenda. I don't think that helped either. Beginning to cut civil legal aid. So the narrative as it played out in reports of cases was not about privacy cases of hairdressers or anything. It was always about terror suspects and refugees and criminal defendants, the people who were still getting legal aid. I don't think that helped either. I do agree that it's now shocking that you've got a government of so-called Conservatives who are effectively trashing a convention that Conservative lawyers were once so instrumental in drafting. And I think that whilst there was insufficient public consultation about the Human Rights Act, at least it was a piece of Labour and to some extent Labour Liberal legislation that was incorporating a Conservative convention that a previous Labour government was rather suspicious of. So there was an element of bipartisanship, at least about the underlying values. It's not easy to compare with Canada and other sort of slightly post-colonial situations for the reasons we discussed before about the national myth and all of that. But we are where we are, and I think we're now dealing with a very, very different proposition and a very different constitutional moment, which is based on real crisis that has been developing since 2016.
This is a fascinating conversation, and one that's going to continue, but I think we should probably try and continue it somewhere else at future events and on our blog. And I'm reminded that, of course, Francesca, when I said Francesca, welcome back, it's because Francesca spoke at the event for the 25th anniversary of the Constitution Unit, which was 2 years ago. And she wrote a great piece on our blog on some of these topics about selling the programme. So, but let me turn to Lisa for another round of questions, which will now be our last, I fear.
Yes, and we're going to finish with a final question from Roger Dorr, which is an invitation to compare past and present. But whilst we unmute Roger, let me ask a couple of other questions that the audience have put. So John Newham asks, all of the devolved bodies set up after 1997 used proportional representation. In light of that, was the failure to reform the Commons voting system the greatest omission from an otherwise very impressive programme?
Lots of people would ask that question.
Absolutely.
Sure. Thank you, John.
And another anonymous attendee asks for the panelist's views on the powers of the Supreme Court. Does it have enough powers currently? Should it have more? And then we'll go to Roger for our final question.
Yeah, which is, as we approach the 2024 election, why are things so different from the approach to the 1997 election, including the prominence of constitutional issues?
Goodness, there are so many questions that we could ask. Let me pass to Shami first on this round. Should we start with you?
Well, on the last question, why are things so? Look, I can't run away from my past, or anybody else's. I was very, very critical as the Director of Liberty of aspects of Labour government policy, particularly around the war on terror, but also aspects of criminal justice and refugee and immigration policy, and also, the occasional denigration of BMW driving lawyers, etc., etc. Some of that rhetoric, some of that narrative that was then adopted by Conservatives, that was unfortunate, and that stands in great contrast with, for example, what Nelson Mandela did when he would lose cases in his new constitution. He would often say, well, this is what we fought for. We fought for the rule of law and our human rights and our constitution. So I'll take it on the chin, and I won't complain. There were aspects of the Labour's time in government that were not helpful for what happens subsequently. But at the end of the day, going back to 97, it may have seemed an elite sport, but it was a progressive constitutional reform ambition and not a reactionary one. And I'm sorry to say it, but the current so-called constitutional reform agenda, whether it's just threatening the House of Lords with abolition rather than having a progressive agenda for a Senate of the regions of and nations, or for an elected second chamber, just threatening the Lords with abolition if they stand up for our rights and freedoms. That's a very different kind of agenda, as is this so-called Bill of Rights with which we're being threatened. This is a populist, authoritarian agenda. It is not something that we can call constitutional reform in the same sense of 96, 97, regardless of the criticisms of what came later, not really in the constitutional arena, but with things that impact, like your criminal policy, counter-terror policy, and so on. And we are where we are with, a gentleman's agreement when the gentlemen have left the room, and I don't see them in the highest positions in government anymore.
Yeah, well, of course, there is a question as to whether the unarticulated objectives of the Labour reform programme are actually the exact opposite of the unarticulated objectives of this programme, and indeed if this programme is seeking to roll back that one. Shami didn't talk about the electoral system or explicitly the Supreme Court. So Charlie, would you like to have a go, and then I'll finish with Robert?
Yeah, I mean, in terms of the electoral system, I agree, maybe with the benefit of hindsight, because I was never a particular exponent of changing it. That was a big omission. Whether we should be blamed for it is a different question, but my goodness me, we have collapsed in terms of providing effective government, as was demonstrated by the period 2015 to 2019. And part of the problem is our political parties are now, they bust, basically. The Conservatives are David Gauke and the most socially conservative supporters of the most brutal Brexit. Labour is the former Red Wall voters who in many cases are still voting Labour, and also the graduate metropolitan middle classes of cities all over the country. PR would allow a voice for these different groupings that wouldn't involve these incredibly fractured and ultimately ineffective conversations that go on within political parties, and then very frequently produce either bland or very divisive policies. And it would force the way that we are governed to be much more an explicit compromise between the variety of forces at play. So I am now much more in favour of some sort of proportional representation system. And it is, as John said in his question, very interesting that we crafted the Parliament crafted the electoral system for the devolved assemblies on the basis that it did reflect that, because we recognise the benefit of a system that did not give one party, which might be taken over by the Brexiteers, for example, undue power on the basis of 35 or 40% of the vote. The second question, the powers of the Supreme Court. I'm not, as things are at the moment, I'm not in favour of the Supreme Court having more powers. The question is whether or not you want a Supreme Court in our country to have power to strike down primary legislation because it offends against some written constitutional principle. We need to debate that now more. I think there may be something that means, because the checks and balances on the government, the executive, and because of the absence of decent people being prepared to hold back, you wouldn't have a prime minister proposing legislation that is explicitly in breach of an international law agreement that his government entered into only a year or two ago. If you don't have self-restraint, then maybe you have to have judicial restraint in relation to it. And Roger's last question, why is it going to be so different in 2024, a general election with this massive hope that change can come. I'm sorry, 1997, when there was massive hope that change can come, whereas in 2024, that is definitely not likely to be the mood, because people have lost confidence in both their political institutions and their politics and their politicians.
That's a depressing place to end, but we're not going to end. We'll put a pass to Robert for the final word on these questions. Robert.
Two very quick points, because we're into injury time. First, on why the new Labour government failed to implement their manifesto commitment to hold a referendum on the voting system. The answer is very, very simple. It was a matter of political will. When Blair looked round his cabinet, out of 23 members, from memory, only 3 or 4 at most supported PR. And that's why early on it died the death. Secondly, on preparing for the 2024 election, it's been very sobering and quite salutary, I think, revisiting the preparations that New Labour made before 97 and how well prepared they were in 1995 and 1995 onwards, with a raft of serious policy papers about how they would implement all these major constitutional reforms. And sadly, I see no equivalent at the moment coming out of the shadow cabinet. And so, you know, if for no other reason, I think it's been a really useful seminar in reminding ourselves, if you want to make changes, especially big changes, when you get into government, you need to do some serious preparation beforehand.
Thank you, Robert. That is a very good point to end on. And I can see Charlie nodding and writing notes. So maybe that will get through, and 2024 is still 2 years away. I'm sorry we've slightly run over here by a couple of minutes, but this has been a really fascinating session. We could have kept it going for so much longer, and I'm sure we're certainly going to keep talking about the human rights points. We're probably going to keep talking about a lot of this stuff in the months ahead. It just remains for me to say thank you so much to our wonderful panel. Thank you so much to you in the audience for coming. Thank you for your questions, and I'm sorry we didn't get to all of them. And to remind you that this event has been recorded. Within the next few days, it should be made available as a video, and then it will shortly be on our podcast. We will let you know when it's published. And if you've enjoyed it, then do please pass on the link to your family, friends, colleagues. And just a quick plug for the next event. I can give you early warning that the Constitution Unit's annual conference will be held online on the 22nd and 23rd of June with a whole raft of panels and a starry keynote speaker. We're going to be advertising that in the next week, so do keep an eye on our website if you're not already signed up to hear about our events when they come out. You can do so on our website and you'll automatically be emailed when news of that is available. But 22nd and 23rd of June, write that in your diaries now. So thank you again very much to everybody. Thank you for your attention, and we look forward to seeing you at a future event very soon.